everybody. I hope you're all well. Welcome and thank you for joining our webinar today on Irish construction recovery post-COVID-19. My name is Paul Gibbons and I'm the founding director and chief executive of Decipher Consulting. The webinar today will consist of 5 speakers who will be looking at returning to normal and what the Construction Industry Federation are doing in Ireland, insurance implications of the pandemic, dispute resolution, what is happening, record keeping, and there'll be a Q&A session. And as I say, at the end of this speakers, there'll be a panel discussion that I'll be facilitating, and we would welcome any questions that you may have. So please put them in the chat box. I'm very pleased to be joined today with Paul Darling OBE QC from 39 Essex Chambers. Paul has established a formidable reputation as an advocate in tribunals all over the world. He specialises in complex cases which feature multiple parties, large teams and high volumes of material. He has an ability to work with colleagues from any jurisdiction and to grasp detail, strategy and tactics quickly, which has allowed Paul to develop a practice which has taken him to every major jurisdiction in the world. Paul will moderate the session today. I'm also pleased to be joined by Shane Dempsey, Director of Communications, the Construction Industry Federation. Shane has provided corporate communications and government relations expertise to Ireland's leading indigenous and international companies. Shane and his team are responsible for devising and delivering external and internal communications strategies on behalf of the CIF. I'm also pleased to be joined by Sarah Conroy, partner at Beale Co. She has experience of insurance litigation and commercial litigation before the Commercial Court, the High Court and Tribunals of Inquiry. She has acted for insurers and self-insured clients in relation to all types of professional indemnity claims. She has also co-authored the Irish chapter of Professional Secrecy of Lawyers in Europe, published in 2013. I'm also pleased to be joined by Martin Cooney, partner at Byrne Wallace. Martin is a partner and head of Byrne Wallace's construction law team. He advises in all aspects of construction law, including both contentious and non-contentious matters. He has a wide-ranging experience advising on standard forms and bespoke contracts. He is a skilled litigator. Martin has expertise in various forms of dispute resolution, having represented a wide range of clients in numerous dispute resolution forms. And finally, but by no means least, I'm pleased to be joined by Bill Bordill, a director of Decipher Consulting. Bill is an experienced quantum expert and dispute resolver. He brings industry insight gained over 3 decades in senior positions with both contractor and consultant organisations. Bill is a discipline lead for our quantity surveying division at Decipher Consulting. Without further ado, I now hand over to Paul Darling to moderate the session. Thank you, Paul.
Good morning, everyone, and welcome. It's rather nice to be moderating the A-team in this excellent webinar. A couple of words about me before we start. It's delightful for me to be moderating a seminar on the Irish construction industry. As I think some of you will know, I was lucky enough to be briefed and appeared in the many parts of the pyrite litigation, consequence of which I got to know what was the 4 Seasons in Dublin rather better than probably anybody in the country at the time. And I appeared in the High Court in 2 trials, the one at Clonskeagh, and then the Elliott case in the High Court. Was then lucky enough to appear in the Supreme Court in the culmination of that part of the dispute. I absolutely adore being in Ireland, and it's a great pleasure to me to be with you all this morning and to be helping moderate this important and valuable session. I'm going to ask Shane to start. The format we're going to use is we're going to have 5 minutes of introduction from each of the speakers. I'll then throw in a few comments and questions, and then we'll move on to the next, and then at the end we'll have the session that Paul was talking about of general questions. Do use the Q&A facility. These webinars work best when people are sharing their respective experiences. So with that introduction, Shane, can I ask you to unmute yourself and give us 5 minutes on where we are in Ireland in the construction industry at the moment?
Great, thank you everyone, and thanks for attending this morning. It's a great lineup, but as you've said, myself excluded, of course, Paul, not on the A-team just yet. So look, since May the 18th, since the industry kind of emerged from the induced coma, that the government put us in as a result of COVID, there's been a kind of a very rapid kind of restart on sites around the country. There's about 1,100 sites around the country, and we'd estimate that 90% of them are back up and running. At what capacity will vary across the sites and the projects, and will be affected by a number of factors we can talk about later on. A colleague company of ours, Construction Information Services, did a recommencement survey pretty much at the end of May, and it found that of the 550 sites, over 5 million that it surveyed, they were all back operational. And from our housing side, again, around 90% operational. On a positive note, about 164, this is the beginning of June, 164 projects, new commencements had begun. So there's a general positivity around the return to work. And this discussed at the last webinar, was enabled by, I suppose, the work of the industry and getting a safety protocol in place that really gave the government comfort that we could go back to work, and in many ways led all the other sectors in the economy. Part of that program was an induction program, and we have had 184,000 people go through it in the last 6 weeks. The CSO, our Central Statistics Office, classify 147,000 people as construction workers or working in the construction industry in the widest possible sense, including designers, engineers, etc. So we're scrambling around trying to figure out who the other 30,000 are. We imagine they're suppliers, people on site, but there's an exercise there for us to do. The reports from the sites, and there's, as you can imagine, a big focus on productivity. It started off low. People, larger sites put 25% of their staff on site, and then ramped up over the coming period. So look, that has implications for the next couple of months as people sit down with public and private sector clients and say, this is the pre-COVID period where we're operating at this level. This is COVID when we were shut down, and then the post-COVID area and out to the future as we look at future contracts and so on. So I leave better experts than me to talk about that, but putting a figure on it, it's what I get asked all the time and everyone in the house gets asked on. It's very, very difficult to do. There's a fixed cost element that you can quantify, and there is, positive engagement between the industry and its clients on what fixed costs are. It's quantifiable. You can almost, touch it and feel it, but the softer costs around the introduction of social distancing and the kind of long-term productivity measures are very hard to identify. And I think it'll be, we need a bit of distance from this and a bit of retrospective viewing to see what the actual costs will be. We have done internal surveys, as you can imagine, on productivity with our members, but the scatter is so wide it's impossible to give a general figure. But we've been engaging with the Department of Public Expenditure on the public sector side, who are obviously very concerned about the introduction of a new government, the introduction of a stimulus plan in July focusing on infrastructure and housing that's in the making, and all of a sudden the industry and all their public sector clients are involved in arbitration and worse, we'll say, in terms of COVID costs. So there is a willingness on behalf of the Department of Public Expenditure and the wider government to give the OGP and the public sector clients a bit of space and flexibility to work with contractors on dealing with the unforeseen costs around COVID. And that's a key thing, where the productivity, I suppose, improves quicker when there's real collaboration between clients and contractors, and we've seen that across the board. So that's the sum up. All the other thing I would mention is we have a program for government that may or may not come to being. There is a huge focus amongst all the parties on increasing investment into the NDP, into the public capital program. So it's really essential we get this COVID costs issue resolved as quickly as possible. I'm looking forward to the future. We're looking at two areas to help reduce disputes in general, not to make anyone on the call here redundant or obsolete, but we're looking that there will be a major reform of the government contract, so that it will go from this lump sum fixed price type of approach and procurement model to one where there's more collaboration and risk sharing. And then number two, the impact of digitalization on the industry, the use of BIM and other technologies, that kind of clarity around operations on site can really have an impact in resolving and staving off disputes. So there are two areas we're looking at. I think we've lost Paul. So Paul, you might unmute there. Sorry.
Thank you, Shane. We seem to have lost Paul Darling there temporarily. Thank you, Shane. That was very interesting what you were saying there. What I'd like to do now is just move on to Sarah Conroy and her explanation in terms of insurance and what you're seeing there, please, Sarah. Sarah, you're on mute. Sorry.
My apologies, Paul. Thank you, Paul. And just to say thank you both to Decipher and to Limeslade for inviting me to speak today. As Paul mentioned, I'm going to talk a little bit about the insurance industry and the implications for the future in terms of, I suppose, in terms of construction and in terms of consultants, which would be kind of my bailiwick. As a lot of you probably know, we do a lot of work in terms of working with architects and engineers in respect of claims under their insurance policies and otherwise. So a couple of things in relation to the broader insurance industry I'm going to touch on, and because it is relevant, and then to focus for a little bit on construction as well. So I suppose to deal with firstly the thorny subject of business interruption insurance, which obviously is not unique to construction, but in relation to a lot of industries at the moment. I suppose the first thing to remember about standard business interruption cover is that it doesn't always cover forced closure by the authorities. It can sometimes do so, but that does not mean that all the standard business interruption policies that a lot of businesses had over the course of the past number of years cover them in relation to the recent pandemic. It's intended to respond to physical damage at the property which results to the business being unable to trade, and the purpose is to indemnify the policyholder against any loss in gross profit as a result of a reduction in takings or any additional expenditure. Just so that people know, a test case has been mounted against FBD here, and there's 4 cases, but they're of interest to about 1,000 pubs in Ireland, and they're due to be heard on the 6th of October next. And the purpose of that litigation is to deal with issues of interpretation, what is an insured peril, causation, and the extent of indemnity. And obviously that's going to be of interest to anybody who has a business interruption policy, but I think more broadly in relation to anyone who has a policy generally, those issues are going to be of interest. The Central Bank of Ireland did send a letter on the 27th of March to insurance companies indicating that the interpretation to be given under business interruption policies was that was most favourable to the client, and that should prevail. There's a similar case involving Allianz as well. I suppose it's important to remember that those policies, although good to have them, don't necessarily cover you for COVID-19. So that I suppose the outcome of the litigation involving FBD and Allianz here may well have a knock-on effect in relation to other types of policies, such as those under professional indemnity headings, which I'm going to deal with now. And I suppose that probably professional indemnity insurance is probably the sort of cover that a number of the attendees today would be most familiar with. Obviously what it is third-party cover. It's to cover you for any element of professional activity and to compensate for civil liabilities. And it is difficult to see claims arising purely out of COVID-19 in relation to that, but important to remember that there are things that may not be directly related to COVID-19 that may become very relevant in the months and years following this as the country begins to reopen. I mean, the issue really is in relation to things such as impairment to everyday operations caused by COVID-19 and what flows from that. And you could see ways that might lead to errors in day work. So I mean, it will lead to things like such as difficulties in getting insurance, and the issues that we've seen, such as problems in relation to home working, a drop in supervisory ability and standards generally, or a general decline in standards. In particular in a situation where there might be poor systems or poor diary management. Matters can fall between cracks or deadlines are missed, and there can be a risk of claims due to a lack of oversight, an inability to access, for example, hard copy materials, a dearth of face-to-face meetings, an inability to do due diligence in the normal way. Desk-based evaluations can be very difficult for consultants or those in the construction industry, and also an inability to maintain full control of staff could lead to, potential errors or potential claims, and you can all see how that would happen. I suppose in terms of where we might see it in terms of construction claims, I think the first thing that's going to arise, what obligations consultants have to warn clients of the ramifications of COVID-19. You can see how consultants' decisions in relation to extensions of time and in relation to additional fees on projects might be opened up for scrutiny. You will see that issues such as overruns on site might be allocated between all parties, which could lead to an exposure under a number of different policies. Is going to lead in, I think, probably an increase in claims from desperate claimants. Any decisions made to terminate contracts on site are also going to be open to scrutiny. I suppose one example I've heard of in recent days involves a major US client of our firm, and they've indicated their concerns with remote working, and there's I think a concern that it affected the quality of some work. That in their view, final execution has not been up to scratch. And that's the sort of thing that's usually picked up by design directors wandering around the office and looking at final drawings drawn up by more junior staff. And I suppose they've taken the view that obviously that practice, although it worked very well in the past, is obviously not going to work going forward, because I think we all agree that there's not going to be a return to, I suppose, the sort of in the office working that we previously expected. And they're expecting their design directors to systematically review projects going forward. And that's obviously much more organised than ad hoc reviews. Just generally, I suppose, in relation to claims under public liability or employer liability policies, there may well be claims alleging that firms were slow to react to the pandemic, and you can see how that exposure might come from both employees and also members of the public, and that's due to COVID-19. But that's for the future. But that's the sort of thing we might expect to see. I suppose then looking to the future in terms of the professional indemnity insurance market. Don't like to be the one to mention the R word, but Shane will know that the CEO of CISC, Steve Bocott, indicated last week that he's of the view that Ireland will enter a recession next year, and it really just depends on the size of that recession. The new programme for government has set out funding for infrastructure and housing, but he says even despite that, that he does think there's more on the way. Now, I suppose in terms of the professional indemnity market and the effect that might have, you'd see difficulties with getting insurance. Insurers are going to be focusing increasingly on the financial viability of their insureds. And I suppose they're going to be very cognizant of the fact that challenging financial conditions are very conducive to disputes. The fact that margins are decreasing due to value engineering and cost cutting, and the things that are arising out of D&B procurement and lengthy supply chains, and that it can be more and more difficult now to effect recoveries in relation to issues that arise on site. The procurement environment is tough. Contracts are onerous. Issues such as fire safety and building regulations and testing regimes are seen as inadequate. And just general economic and political uncertainty. Insurers will be looking at things such as, contingency plans and liquidity going forward. And I suppose in terms of restrictions under policies, we're already seeing restrictions in relation to anyone who's involved in any type of cladding. There'll be restrictions in relation to fire safety, I would say, and then onerous COVID-19 exclusions going forward. And I suppose brokers generally, in advising their clients, will be looking at things like contractual risk management, supply chain management, and technical risk management. So I suppose in terms of those looking for insurance going going forward. Those are the sort of things that insurers and brokers, I think, are going to be focusing on. I suppose in relation to, and then one feature of the market, although not a massive issue here, is single project insurance in relation to particular projects. And generally it appears that the appetite for that single project insurance has decreased going forward, and there are some insurers who are not writing that business at all. So I suppose a whistle-stop tour of where things currently are in relation to the insurance market and in relation to the way we see things going in relation to professional indemnity going forward. Any questions from Paul who has rejoined us? Or
Thank you very much. Thank you very much, for Sarah, for so seamlessly continuing as the North London Internet decided that this was the moment to play silly so-and-sos. What I was going to do, we're going to have Martin in a couple of minutes or a few minutes to talk about where we are on the dispute vista at the moment. And I'd be very looking forward to hearing about that. But I thought before we did that, Shane and Sarah and I might discuss what the mood is at the moment. What's the mood between contractors and employers? What's the mood? Is it optimistic? Is it panicked about the past? Is it heading for disputes? Is it, how do people feel? Shane, do you want to go first?
Yeah, well, look, it's as it ever was, whether there was COVID or no COVID. There's always tension there. But I think it is probably more acutely felt on the public sector side. Because of the nature of the contract. I think the contracting authorities and their budgetary considerations and the lack of government and, an ability for the government or the Department of Public Expenditure to give them any clarity, I think that's causing them hesitation. And as a result, they're kind of cagey to engage with contractors on the cost issue. We have been waiting here for weeks now from a letter and an instruction from the Office of Government Procurement that will enable or facilitate or give comfort to contracting authorities that they can work with contractors on costs. So with that lack of direction, I suppose there's a collaboration gap is after opening up, and once there's a gap there, you can imagine what kind of fears, concerns, issues and tensions fill it. So that's on one side, but I'm fairly confident because of discussions we're having with the Department of Public Expenditure that there is capacity being set aside for contracting authorities to absorb the costs and deal with the costs of construction. Okay, so that's coming down the line, but in the meantime, people are quite tense. That public sector side of the contractors, or the contractors with a preponderance of public sector works, are all concerned about the future, and the issues that Sarah's talking about there, the cost of future pandemic issues, building that into contracts, putting all of the cost of that or potential cost of that on contractors, that's causing them great concern as well. And then they have concerns about the future pipeline. Will the NDP, will the new government come in and dollop some stimulus from be it the EU recovery plan or from the bonds market, where money is, incredibly cheap on a long-term basis. So is that money coming? So you're always waiting for Godot in the industry here. On the private sector side, our contractors with private sector clients have been working absolutely flat out, assiduously, to ensure that the productivity issues on site are removed as quickly as possible, because that'll have when the bill is settled, will have a knock-on effect on costs. And reports are very positive that private sector clients are giving, most of them are giving contractors space to embed the productivity measures to, get them onto site, make sure everything is safe. And they're given time and space. So there's been ongoing, as you can imagine, discussions around what will the cost be, but as yet it's too early, and the contractors haven't been able to are not able to calculate it yet, because like tomorrow or next Friday they could reduce social distancing from 2 meters to 1 meter, which would have a profound effect on productivity on the site straight away, and that would change the overall calculation. So a long way, it's all a bit too early to say what the cost would be, but within that ambiguity, there's always increased tension. So that's probably controlled civilized tensions, the impression. Yeah, I think so. Yeah.
Sarah, in the insurance market, obviously there are two ways to, one's looking back at what's happened and one's looking forward as to what arrangement people are going to make for the future. Is the mood positive, or is there tension, or people do we think there's the claims building up? Are they bubbling at the surface? What's the general feel?
I would say, I mean, like this didn't all happen because of COVID-19. I think probably the insurance market was challenged in any event, and this has certainly quickened the pace in relation to that. I think, I mean, the good thing about things like, you know, business interruption, there's an immediate need, and you know, we'll see that wash through pretty quickly, I think, in particular with these test cases being heard in October, in terms of business interruption. But I think the balance of claims, in general, there would be a long lead-in time in relation to things like that, and I think that's anticipated. But they won't really crop up until people start returning to work, and that's only happening at the moment here. I suppose more generally in relation to claims on construction sites from employees, etc., that again will only start to wash through in the near future, and you know, people have a certain amount of time to mount those claims, and they'll take that time. And then I suppose in terms of, you know, disputes in relation to things like extensions of time and all that, I anticipate that they might crop up more quickly. But I suppose in relation to the insurance side of that, which is passing that on to the consultants or, you know, the other entities on site that have their own professional indemnity insurance, that's going to take longer. But I think it is anticipated one way or the other that there will be claims that arise out of this, and that at this stage it's impossible to tell the volume or the nature of those claims, but it is anticipated that there will be claims. And I think for that reason, the things that I spoke about at the end in relation to what insurers and brokers are going to be looking at are going to be very fundamental. I should say that the building regulation regime that came in here 3 or 4 years ago, in relation to traceability and accountability on site, and the appointment of the assigned certifier, that has really helped in terms of, you know, things like contractual risk management, all that sort of thing, which means that, you know, a lot of firms are kind of much more geared up for this than they once were. But still, you know, I think insurers in particular, you know, and it is London insurers coming here and looking at the market, they're going to be a lot more cautious about what they do, what they write, and what's to be anticipated.
Good, thank you very much. So therefore, that way of summarising that is, we're in the calm before the storm. No one knows quite how big the storm will be, but some sort of storm there's bound to be. Okay, with that, Martin, that'd be a convenient segue for you to tell us about your experience of the impact on COVID-19 on disputes and how they're executed. When you've done that, I'm going to throw in a bit of my own experience of virtual hearings, which I think you may also touch on. So let's hear from you.
Yeah, Paul, I like the analogy of a storm. So I'd say you're the lighthouse guiding us to safety, whilst the contractors are captaining the ship heading for the rocks. So just to kind of expand upon what Shane was saying, I actually had a surprising experience with the private sector when the shutdown was announced, in that I found that private sector employers tended to work very collaboratively with contractors in terms of dealing with the impacts of the shutdown. So there was generally an agreement on what would be the standing costs, what would be the pain share between the parties, and how they would deal with the issues. You know, that surprised me in terms of the difference in approach compared to the last recession. However, that has to be borne in mind of the context that it was a statutory shutdown when the legislation or the statutes, the regulations were eventually implemented, and also there was the government support for employees and for companies. So that all helped with that collaborative approach. On the public sector side, then the ex gratia or ex gratia payment was introduced, which assisted the public sector in dealing in a somewhat helpful manner with their contractors, and that helped everything being cooperative at that point in time. But then following on, you know, what Shane was talking about is what happens now. So we don't have that process for the public sector for all of the impacts of health and safety and coordination and acceleration and disruption on site, and the impacts in terms of complying with social distancing and trying to make up time are significantly different in terms of the costs that contractors are facing now. So whilst there was a lot of collaboration around the shutdown, it appears that that goodwill waned as time went on, and that it now looks like we're going to have a lot of claims. In that context, what I found as well is that we've had a raft of disputes, but the disputes don't relate to COVID-19. They're disputes that were gestating before the COVID-19 shutdown came along. And then what happened, obviously, is people had more time on their hands to reflect on the disputes and to prepare them and to get their documents together. And equally, people were looking at their cash flows and figuring out how they were going to get money in a couple of months. So this is where adjudication really came to the fore, in that even if there was conciliation or mediation in contracts, contractors weren't really willing to sit around and wait that long for a conciliation to occur and to get a recommendation which might not be binding. So adjudication became a very attractive option. I think there's been some reluctance in the industry to use adjudication to date because of perceived reputational damage, also the perception that it might be somewhat aggressive, and that if you take that approach, it may taint you in the industry. That's combined with a number of other factors, but it was one of the things that parties were taking into account. We'd already seen an increase in adjudication in the industry. I think in 2019, the Construction Contracts Adjudication Service had indicated that there were 34 adjudications that they had received referrals for. Last year in October, one of the appointments I got was, it had a reference of number 30. And I did another 4 adjudications myself between that adjudication and December, and one of them was outside of the CCAS. So, I can only expect that when the report is provided this year, that the numbers were even higher again than last year. And I definitely saw a marked increase in the use of adjudication. Now it appears to be one of the only games in town in terms of in my clients when I'm speaking to them, because it's about getting cash quickly. They're not willing to wait around. The need for cash and the need to protect cash flow supersedes the reputational risk, supersedes any perceived damage. And that's the general viewpoint. So I've had one adjudication concluded already. I'm in the middle of another 2. And I've another few brewing, where it's all people who have conciliation or arbitration as options, but are just want to move on. In that context, then I suppose the virtual hearings has come into play to a certain extent. Now, I haven't found it in adjudication. My experience to date in Ireland is that adjudication has predominantly been paper-based, and any submissions have been dealt with that I've been in have been dealt with by conference call, which is a contrast, because the only time I did a physical hearing is in London on 2 different adjudications under the 96 Act and the statutory scheme. So, the funny thing is, in Ireland, we were saying constitutional justice would demand hearings, whereas the only place I've done it was in London. So a bit different to how we expected things to turn out. But what we are finding around mediation and conciliation is that the technology does work, but it has advantages and disadvantages. So first and foremost, lessons learned is you have to test the technology in advance. It's no good trying to log in on the day, because invariably there are issues. And a point in fact is this morning with this webinar, the participants had issues getting on, and even though I've been logging on since 8:30, I got on. Yeah, and we lost you. So and that's critical, especially if you're doing a submission on a jurisdictional point in adjudication. And my preference on those kind of things is to use a conference call. It's tried, tested, it doesn't drop, and you can get the points across, and there's no real need to be looking at the shine off my head on a video, so you use the method to suit your process. I find it is useful in terms of you can get parties together much more quickly. You don't have to travel long distances from contractors all over the country to get them into a meeting. You can engage in without prejudice or settlement talks through it, and then the mechanisms can allow you to mute or to cut off your video if you want to discuss amongst yourselves. And my colleagues who've been in court have found that it worked very well in terms of the judge controlling the process and allowing barristers to speak at any given time, and then sidebar apps were open to allow them to instruct counsel. So it does have its advantages, but again, other things to consider is it's very difficult in negotiations to beat physical presence and to beat the ability to read body language, to understand the reactions of everyone in the room as you speak, including the third party. And you know, even with Zoom and having all the parties on the screen, it's still very difficult to gauge how people are taking things, to gauge how points are landing. And also there's a delay, because as the internet takes my voice, packages it into information, and it travels along, and then it's repackaged. Different computers do that quickly, you know, more quickly than others. It depends on your broadband as to how quickly that lands. So you have to bear in mind that there can be a delay in transmission of information also. So they do work, but I select it for the process that I think it's appropriate for.
Well, Martin, that's very interesting. It reminds me, when I was a baby barrister, I was told by my people master that if you get yourself to the right place, the right time, with the right papers, the right books, and the right clothes to wear, you're halfway there in this job, which was used to get when I was on one occasion late turning up in Dublin by my junior, Tom Hogan, now SC, who looked at me and started to mouth the mantra. But actually the mantra's changed now, because, you know, is your internet connection working? Is your microphone working? Is your video, have you got a dog or a child in the background? What you say is very interesting on 3 levels. One is obviously, for me, the growth of adjudication in Ireland, I think, is interesting. Secondly, that it has gone down the adjudication route rather than mirroring, as it does in some places, court procedure, and which one is seen in some places. So that's interesting. Secondly, that there is that it's taking out that a lot of it's being paper-based. But I also think that you're completely right, that the other interesting thing is the flexibility of means of communication. You know, for goodness sake, why not just use the phone sometimes? Because actually, you know, Zoom meetings where internet connections drop can be down, can work badly. My own experience of virtual hearings, and I did a very long webinar which is online with Limeslade to discuss this, is we managed to run a trial very, very effectively. And I was very pleased with the way it went. I didn't feel any disadvantage with the judge. The witness was as close to me, in fact, closer to me on screen than they were in court, because I didn't lose the intimacy there. And you learn the technology tricks. But I've since had a couple of hearings where I've been making submissions to a judge, and I have felt quite strongly that I haven't been able to work out, because of the lack of proximity, quite how they're going down. Whereas if you can see and interact, so that's also going to need to be fed in, and we're going to need to learn those tricks. My own feeling is that what will happen is that we'll use this technology so as to keep the show on the road in the meantime. And when we have options to think about it, I don't think it's going to all necessarily carry on the same. I think that physical hearings in court will still have their advantages, but it'd be interesting to see how it develops. I've also been teaching everyone in London a lot of Irish techniques. The use where you have document managers with documents onto screens, that's regarded as very much modern and new in London. I keep on saying we've been doing that in Dublin for 15 years, at least to my personal knowledge. I get some funny looks for my indignation about that. But I think that's very interesting. Thank you very much. Now, we decided, the organisers, that we would ensure that this seminar was not just going to be me and others gassing about how interesting and difficult things are. We thought we would have some proper content of how you actually do projects. And so we're going to ask Bill to give us a bit on claims before we have a general question and answer session.
Okay, thank you, Paul. I'm going to talk about record keeping. Record keeping is not a sexy subject, and I'm not the person to make it so. So I just want to give people some ideas and hopefully give them some tips on why they should keep records, what are good records, and how to collect those as they go through the projects. So why keep records? Well, there might be a contractual requirement to update site progress records or maintain an as-built program. There might be a legal requirement for maintaining health and safety records. So there's 2 very good reasons why you really must keep records. Records provide a factual evidence to support or substantiate a claim. That's a good reason, and we'll come back to that later. But perhaps more fundamentally, it demonstrates good management and strong contract administration. If you're maintaining records as you're going through a project, it creates the right impression both upstream and downstream, and it leads to a better project. Now, things haven't changed greatly. 65 years ago, the great late Max Abrahamson, a Dublin lawyer, said there were 3 essential ingredients of a successful claim. Number 1, records. Number 2, records. And number 3, records. That hasn't changed in 65 years, but maybe what we record and how we record it has changed. So now I want to talk about what we're going to record, or what you should record. Essentially, it's what happened on site, what date it happened, where it happened on site, who did it, and why. So what documents would we use to collect that sort of information? Well, we'd look at site diaries, safety records, labour allocation sheets, day work sheets, as-built programmes, as-built records, programme schedules, progress meeting minutes, instructions, verbal instructions, even conversations if they're relevant, and progress photographs. These are all things that should be recorded and give you supporting information that you may be able to use later. So now I want to look at how we record this information. That's something that has changed over the last 65 years and is now very, very different. We all use emails. There's a way of managing emails, and I'll come on to that, but emails is a way of recording information. Drone surveys, that's latest technology. GPS tracking and external works projects, cameras on hard hats, site videos, time-lapsed still photography, where the camera in the same position takes the same photograph every 15 minutes on a project from start to completion. Biometric site entry records. These are all great ways of recording information. So now I want to give people 4 top tips. The first one is create an issue store. So in your site, on your site server, start recording anything that happens so that you can return to it later. Collect the information at the time so you're not having to collate it later. So a site, an issue store would be a repository where there's a database giving a specific number, a reference number to each event, and there's a folder there that you can just collect drawings, emails, conversation, any notes or records you might have maintained, collect them in the issue store. Second top tip is have a strategy for email filing. File your emails in such a way that you can get to them later. So have a structure that your subject of your email tells you exactly what that is to do with, and create a project email address so that every email on that project, whether it's received or issued, goes into the one email repository so that everything can be found. It's very expensive to engage consultants later on when there is a claim to go through 20 or 30,000 emails, which is easily possible on a project, just to find the few golden nuggets that are relevant. So have a filing structure that enables that information to be retrieved easily. And the third top tip is to standardize your record keeping documents. Have data entry fields, populate them with drop-down boxes so that it's easy for people to fill out the records you want them to collate. And there's a consistency across all of the information that you've maintained. Obviously, the standard boxes can be overwritten with specifics if necessary, but that's a much easier way of encouraging. Nobody wants to keep records. They see it as unnecessary and an administration burden. So make it easy for them to keep the records. That's the tip there. And the fourth and final one is create contemporaneous records. And by that I mean not only create them at the time, but share them at the time. If a record isn't refuted, it's shared, but it's not refuted at the time, it provides the strongest evidence you can have later on. And that brings me to my conclusion and back to evidence. Any tribunal will ascertain the facts, apply the law, and then reach a decision, an award or a judgment based on the strength of the evidence. It's the evidence that really matters. So contemporaneous records provide the strongest form of evidence. Maybe that's one for Paul to pick up on.
Yeah, no, well, that for me is, I mean, one of the reasons I think we were keen to have that session is to remind us all that we can talk till we're blue in the face about COVID-19 and all of the things that, all of the issues that gives rise to. Ultimately, what Martin and Bill have been telling us about is to remind us that in amongst all this, business goes on as usual. Different pressures, but it means that it is very important for contractors to bear those sorts of records. I'm at the moment chairman of a committee that is the employer on a large project in London. I hope there are no one from the contractor present on this call to hear your good advice, Bill. Bill, how do you think COVID-19 has affected the record keeping function? People working at home, fragmented working, what impact do you think it'll have had?
Well, in our experience, possibly improved things. I think a number of sites have closed down. Some have been mothballed completely. Some carried on and managed to carry on through. But in our experience, on some of the disputes we're working on, the contractor has furloughed some staff, but maintained some staff just on record keeping and improving the records that they've got. Now, that's not great for contemporaneous records that may have been shared at the time. And we're very careful to make sure that they don't alter those records now. It's important that that doesn't take place, but they are focusing very clearly on maintaining the right sort of records. And you know, that's it. Nobody knows now how important record keeping is. We just know it is important. But at the end of the day, that they have to create the records that they're ultimately going to rely upon to evidence whatever the situation is that they're going to make a claim against.
Paul, I wonder whether you might now run our Q&A session.
Absolutely, thank you, everybody. Just a bit of a tongue-in-cheek one to start off with, in terms of Shane mentioned collaboration, and immediately Paul Darling was off as a statement here. So
yes, the word collaboration came, and the line went dead. Obviously, obviously the firewall's working. It is working effectively.
Absolutely. Just moving on there to some questions. There was an observation initially. This is an observation. It's a fascinating point that's been made by Martin with regards to the way that we package and present information with regards to disputes and how we communicate that online. Do we have any thoughts in terms of, you know, what does good look like? I mean, is there an overzealous burden on just putting everything, including the kitchen sink, into an electronic WeTransfer? And what's people's thoughts on that?
Well, I suppose in terms of an adjudication, I find that clients tend to want to dump everything into a Dropbox or a WeTransfer. And like, what the hardest thing for us to get into the Irish mindset, because we're not used to it and we haven't had it for over 20 years like the UK, is that the adjudicator has a very, very limited amount of time to consider the information. So the way we package the information in terms of delivery, making your points, and making it as easily accessible and traversable as possible, the easier it is for the adjudicator to get your point. So how you package, you know, when I be advising on a referral, I'll be saying, look, if we can package witness statements with the narrative, let's do that as an exhibit and keep to the key points in the referral. If we can package key emails, do that. Don't give me 34,000 emails like Bill was mentioning there. If we have a quantum element, let's have one exhibit with the quantum element, which allows him to review it. And ideally, let's get a quantum expert's report, so he doesn't have to go through Scott schedules and receipts and invoices. He can just look at the report. It's always a balance of trying to get the key evidence across. But equally, the clients want to deliver everything because they believe everything is very important, even if it's an email about opening up the site at 9 o'clock on a Friday in 2017. And it might have no relevance whatsoever, but they want it there to show they were opening the site on that day, when fundamentally you can't say to them, nobody cares. So you're trying to balance it. You know, and it's a difficult thing. Also,
It is definitely a case of less is more. Pick out the real golden nuggets and focus on those, I think, is the message, isn't it?
If you could get your clients to act as adjudicators for once, they'd understand. When I sit as an adjudicator and as an arbitrator from time to time, as part of my work, and the delight you feel when stuff is presented to you comprehensively and simply, and the panic that you feel when you just get this information dump, it is so total. And I think but this is the key of advocacy generally. The great advocates are those who make it all simple and clear and understandable. And that's not just arguments, that's the quality of information, not just the actual presentation, it's the way it's all structured and organised. And I do think that actually being an adjudicator gives you a real advantage when you then act for a party, because you understand what it is that works.
Absolutely. Thank you for that. This is a question, I think, for you, Sarah. Will we likely see insurers increasing restrictions or reducing scope of cover in the future as a result of COVID-19? What's the market telling us at the moment? You're on mute, Sarah.
You're still on mute. Yes.
Yeah, sorry, thank you guys. I think what we're expecting is that there will be a significant COVID-19 exclusion in PI policies going forward. Speaking in relation to business interruption policies, the ones we've seen, a lot of them, firstly, don't have a list of notifiable diseases, and secondly, definitely don't refer to COVID-19, and that's obviously to be expected given that nobody knew about it this time last year. But what we'd be expecting is that in all PI policies going forward, there will be a COVID-19 exclusion, and a pretty significant one. Haven't seen any wordings to date, but when these policies start being renewed and we start seeing them when the claims start coming in, that's what I would be expecting. And I suppose that's going to be relevant going forward because a lot of claims haven't been notified yet, and obviously, like most policies, they're on a claims made basis. So if you get a claim under a future policy and there's a COVID-19 exclusion, you're not going to be covered for it. So that's a question on renewal. I think people are going to have to be talking to their brokers about. But what I'm expecting are significant COVID-19 exclusions in PI policies going forward.
Okay, thanks, Sarah. And just moving that on, Shane, in terms of, we mentioned that there's been quite a bit of collaboration in the market, but before the insurance markets start to change their products in effect and risk profiling, should there be if there's a second spike, do we think that the collaboration will continue, or do we think that the employers will do a risk transfer and try to push that back down to the supply chain? What's the thoughts on that? Because obviously there's a big if there in terms of what if there is a second spike, and how do we follow that through?
Yeah, I missed a couple of words, but I think it was second spike, which you repeated. So if there is a second spike, will the collaboration maintain? Yeah. Look, the collaboration, as Martin actually alluded to quite well at the outset, there was a huge amount of collaboration because it was an unforeseen issue. And people were putting all the potential costs in a black box, and private clients were telling contractors, put it in a black box and we'll talk about it afterwards, but keep records, keep very good details, and we'll share out the costs somehow on a contractual basis if it's there or otherwise. So, but as Martin alluded to there, as pressure builds and, cash flow becomes tighter and tighter, and, the measures that are in place now aren't removed, the pressure will continue. So I do expect, as people have alluded to here and Paul has mentioned, a storm of some sort. We hope it's not I never know which end of the scale is the worst, but we'll say we hope it's not a force 10 gale, and that some of these issues can be worked out. On the public sector side, I think that the collaboration really hasn't started yet, if that makes sense, that the collaboration that Martin alluded to between private and private sector clients and contractors. Now, the nature of that collaboration will be dictated by the kind of quantum that the central government are able to put in place to deal with COVID costs on contracts. But I'm strangely, and my members will kill me for saying it, I'm strangely optimistic that there will be a relatively big stimulus coming down for infrastructure to keep the pipeline going, and also there'll be money to help absorb and deal with COVID costs. So it's funny, I'm less optimistic on the private side, because there will be at some point a day of reckoning. But I think on that side, the private client side, everything has been done in a collaborative way to reduce the overall cost at the end, so that in the end could turn out to be, there will be disputes, of course, but again, we're talking about the degree of storm we face.
Won't that partly be affected by what happens to the economy? Because if the developers, if the economy either declines, stays the same, or goes up, that's going to really impact on the private sector's developer side ability to throw a bit of money at this to make it go away. And if there's a big recession, then obviously there's going to be a lot of trouble. If Ireland continues its marvellous economic recovery, we're very jealous of that in London, then there may be more scope for developers to be more innovative. And I personally found the development community in Ireland has been so innovative and commercial that one would have greater confidence in their ability to sort things out than one would in London.
Yeah, that's a great point, and they're highly innovative. And our budget submission, which I have the honour of trying to pull together for the entire industry, features heavily a number of measures such as a shared equity scheme and other measures that would support private investment. On the developer side, Ireland's still a good bet. Here's the IDA sponsored piece of my webinar. Ireland and Dublin is still a very good bet for international finance, and there's a huge interest in Dublin. And I think relative to other countries, we're having, I suppose, a good pandemic in inverted commas, because we're taking serious measures. So we do see, and coin a phrase here, we do see that there could be a co-dividend coming out of this for Dublin and a number of sectors. So another of measures. So, but we need to get the disputes thing out of the way as quickly as possible, I think.
Super, thank you, Shane. Just conscious of the time, just got one more question. Bill, this is one I think for you, please. What is the biggest mistake that we are seeing when collecting and analysing records?
The biggest mistake, I would say, is they're not shared with the other party at the time. They're not signed. So we quite often see day worksheets that record, labour and hours and resources, but they don't record who was involved in the activity. Perhaps another key one is try and relate the information back to an activity on the programme. Very rarely that happens, so it's difficult to then work with the record that you've got.
Marvellous cross-examination. This says you were working on the site. Where were you working? Don't know. That. Yeah,
it's simple stuff, really. Well, thank you all. I think that's the end of the questions. There's no more questions in the chat box. There's nothing else on the chat on the side of the screen there. I would just like to thank the attendees, all attendees, for attending. I'd also like to thank the speakers. So, Paul, thank you very much for moderating. It's been a pleasure having you do this. I'd like to thank Sarah for your input and commentary. That's lovely. Shane as well, and Martin and Bill for all your responses. I thoroughly enjoyed the session. I hope all the attendees have. And I'd also like to thank Limeslade for setting up the webinar for us. And I wish you all a very pleasant day. Goodbye.
Thank you all very much.
Thank you, everybody. Thank you. Bye-bye.
Stay safe.